The judge and I'm trying to get custody of my grandchildren. And this judge in the case will not let me have a say whatsoever. He says this is a CPS case and not a custody. And the case is out of Georgia. I'm dealing with Georgia. Is a grandparent never allowed to speak?
Well, you know, I'm attorney Vincent Davis. This is The Secret, How to Fight CPS and Win, and I'm joined by my two co-hosts, Amanda Cisco, and the diva herself has joined the live stream, Erin Carranza. So check us out on our different Facebook pages, and you can watch the live stream of the radio show. Ladies, let's take another call right now. Sue from the Hoosier state of Indiana. Sue, did you have a story to tell or a question to ask?
Well, I can't do both at this time. So my question is, the judge and I'm trying to get custody of my grandchildren. And this judge in the case will not let me have a say whatsoever. He says this is a CPS case and not a custody. And the case is out of Georgia. I'm dealing with Georgia. Is a grandparent never allowed to speak?
Well, you know, I mean, I'm going to answer your exact question first, and then I'm going to give you some more information. Whether you're allowed to speak in a courtroom, at least in California, if you're a grandparent, that's up to the judge, right? Judge runs his or her own courtroom. However, there's a big however to it, though. If you were in California, there are certain types of things that you could file to try to get in front of the judge and have the judge listen to your position. Number one, I would talk to or find an attorney in Georgia who would be able to represent you in a CPS matter. What you're trying to do is get the child placed with you as a relative. And there are probably several different types of motions and petitions that you can file. So if you were in California, you'd file a 388, a de facto parent.
Okay, I don't mean to interrupt you, but I do have all those down from you from another thing. I do have a lawyer that's not doing any of this, so I'm going to get on him about that.
Right.
And CPS down in Georgia has completely cut me out from the very beginning of this. They did the intake interview. I had the children in my custody for 3 months in Indiana. The parents live in Georgia. They received the allegations when the children were in my custody. They did an intake interview when the children were in my custody, placed them in emergency care, yet the children were dropped off immediately to me for another 14 days before they even had a first court case where they placed them with paternal relatives who haven't seen these children in 7 years. So then the children are in Indiana also because it's an interstate placement, and the ICPC, the children were placed there June 19th. That was not even complete until March of this year. So it took March, April, May, June. It took 9 months to complete it because in the courtroom, after us hiring a private investigator, we found out the placement, the uncle that they placed him with, less than a month after the placement, he received an assault and battery charge. Plus he had criminal records with drugs and alcohol. And Georgia defects in court, when my lawyer brought this point up, said, we're giving him time to get those cleared up. And since that time, she was aware of these charges, but she allowed him to get them all expunged. Is that even possible? I mean, they did it.
It is
but
possible.
Is it legal? And it's legal?
It's a gray area. I mean, judges can make any decisions that they think is best under the facts and the law. Now, whether you agree with that and you have standing to do it, you can always appeal it or take a writ to ask a higher court to review what the judge has done. Right?
Sounds good.
But these are strategies that you should be speaking to your attorney about.
I agree, but about a month ago, he called and told me, you know, himself and the parent, because it's a single father, his attorney discussed it, and if I would just agree to whatever the judge says and let it come to Indiana, I could open a whole new case for custody. I don't believe that. They were trying to have me agree to just send this whole thing to Indiana. And I said, no, we're so close to the end.
Well, are you not taking your lawyer's advice? Is that what you're telling me?
Well, I didn't take that advice because he said that would be up to me if I just let them change this case to Indiana or not. I didn't. We only had like 3 weeks prior to it was supposed to be the final hearing, but it's been delayed over and over.
You know, I don't know
because of
I don't know all the facts and circumstances surrounding your case, but I'm always a proponent. Usually, you know, if your attorney gives you some information or advice, I'd say, you know, you probably should follow that advice.
Okay, well, I'll have this final hearing then in Georgia and then apply for custody in Indiana after they grant the aunt and uncle permanent guardianship.
Well, if they grant the aunt and uncle permanent guardianship in Georgia, you're going to have to go to Georgia to try to modify or change that permanent guardianship to give you guardianship of the children.
And they told me I could do that in Indiana because that's where both myself and the children are living in different parts of Indiana.
That may be it. That may be correct. I don't know. But from, you know, if it was California, you have to challenge the order in the state where the court made the order. You can't, you know, when a California court makes an order, if people are living in Nevada, you can't necessarily change it in Nevada. Now, there's something called the UCCJEA that might be probative to this issue, the Uniform Child Custody Jurisdictional and Enforcement Act. And you should probably talk to your attorney about that. Okay?
USSEJ?
No.
A?
UCC.
Oh.
JEA.
JEA, and I will.
You can Google that, and that, you know, the law will come up, and you can read it and get a further explanation of what's going on with that. Okay?
Right. Thank you so much.
Sue, thank you for calling us. Thank you for listening from the Hoosier State. Call us in the future and let us know what's going on, okay? Ladies, Miss Cisco, Miss Carranza, before our next break, did you want to say anything or ask me something?
I always want to ask you something.
Not at the same time. Go ahead.
Go ahead, Amanda. Oh, okay. So I had a question I was getting at earlier, Vince. Did you see it? Is that something you want to go into?
You know, there's so many things popping up on the screen from, you know.
So my question was involving hearings in respect to due process. And how, explain that for us.
You mean, why do you have to have due process?
Not why do you have to have due process, but how, you know, from what I've been told that filing an emergency hearing with exigent circumstances, even though most of them don't have supporting evidence whatsoever, are above due process of law, where the parties don't have to be notified within, you know, the required amount of time according to the federal rules of civil procedure, et cetera. So what is your opinion on that?
The federal rules of civil procedure have nothing to do with ex parte applications to a judge in state court. In California, probably in most states, but in California, you can bring certain types of hearings, narrow types of hearings without notice to the other side. However, it's only but this is an important part. Hold on a second.
Emergency hearings are manipulated all the time by social workers.
Okay, so the important part is that if an order is made at one of these non-noticed hearings, that a hearing does happen shortly after that where the person is given notice. So you eventually get notice. They can't just...
But life decisions over families are made during the emergency hearings.
Okay.
Which could...
I'm not civil and... But you didn't ask me the pros and cons about it. You asked me what they do. You know, stuff happens in courts all the time that affect you and that you may think is not fair. All the time. Right?
Again, I only know 5.
You only know what?
I said again, like you say, I know 5% of the law. The other 95%, you know, it should be or would be or could be, you know, isn't it?
Hey, ladies, we're going to have to move into our next break right now. This is The Secret, How to Fight CPS and Win. We'll be right back after these messages.